I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, Barry, if you just want to, so this is the Suffern Zoning Board of Appeals meeting.
Village of Suffern, New York. Notice is hereby given that the Zoning Board of Appeals of the Village of Suffern will conduct a remote Zoom public hearing on Thursday, November 19, 2020, 7:30 p.m. or as soon thereafter as possible on an appeal by 46 Washington Property LLC of 46 Washington Avenue, Suffern, New York, 10901, to permit maintenance and use of a kollel, a reading study hall, religious instruction for up to 20 people at 46 Washington Avenue, Suffern, New York. The approval of such an appeal requires a use variance from the requirements of section 266-22 of the general use requirements of the zoning local law of the Village of Suffern. The applicant is proposing a use variance to allow for the use of a place of worship, kollel, room for religious study, instruction, and services, reading, study hall, which is not permitted use on a PLI zone. The premises affected are situated on the east side of Washington Avenue and is approximately 60 feet north from the intersection of Lafayette and is listed on a Village of Suffern and Town of Ramapo tax maps as section 54.36, lot 1.5. Okay.
Okay, so who is everybody here for the applicant?
I'm here. Hello, it's Joseph Churgan. How are you? Rachel Perez is here also. She's the engineer on this particular project. So
Okay, actually, Joe, I'm sorry. Before you get started, can we just get a kind of a roll call of who's here for the ZBA?
Cary Adwar. Dave Hamilton.
Bruce Simon.
Barry Tessyman.
Andrew Zavoski.
Okay, thank you. I'm sorry for interrupting you, Joe. Why don't you identify who you are, Joe, and you're the attorney, I guess. Go ahead.
yeah, no problem. So my name is Joseph Churgan. I'm an attorney. My office is in Nanuet, and I'm here representing 46 Washington Property LLC, which is the entity that has title, owns the property at 46 Washington. We're here tonight essentially because they want to be using a very small section of the building that's there, 400 square feet, as a kollel. And a kollel isn't the typical thing that most people think of when they think of a place of worship. It really is not technically a place of worship. It's technically not a school either. It's an area where people who are ultra-Orthodox will learn together in small groups. They will read from religious books in small groups. They will debate them. And essentially that's the use that we want to put to that small 400 square foot area. Right across the street is a different zone, and right across the street, your code would allow for, by right, a religious use. But where this particular building is, it's in the PLI zone, and it's unfortunately not, religious use is not within the definition of the permitted uses in this zone. The rest of the property, so to speak, the rest of the building is being used in a like a office type, clerical office, and I'll describe it as, it's not something that's in zoning codes, but the way internet businesses have kind of come up in the last few years. The rest of the property is being used as a type of internet business where there's goods that come in and goods that go out. And some goods are they're stored there during that period of time before they go out. That's a use that actually would be and is permitted under the zoning code. And we're not asking for anything with respect to that. That's the majority actually of the property. It's cut into two 2,300 square foot sections. So you have two 2,300 square foot sections that are being used the way the zoning imagines them. And you have one small 400 square foot section, which they'd like to use for this religious use. And so that's what our use variance request is. And just want to point out to you that under New York state law and also under federal law, United States law, religious uses are given a presumption that they're in the furtherance of the public health, safety, and morals. They're given a little bit of a special inference or a special look by state and federal law. And I know it's discretionary that this be given, but we ask that they be allowed to use this 400 square foot section in that manner.
Okay. And Barry, if it's okay with you, I'm just going to go through a couple of the submissions that we received.
Okay.
So the first one I'm going to go through, and Joe, I'm not sure if you received this or the applicant. The building inspector performed an inspection on the property on November 18th, 2020, which was yesterday. And he had the following three comments. And again, we'll address all of them as we go through the hearing. The first one was that, can you hear me?
Yeah.
The first one was that the Kalel space is currently being used without a certificate of use. Based on the square footage of the room, approximately 620 square feet, the maximum occupant load by state code would be 45 people, excluding COVID-19 restrictions. Number two, the entire east side of the ground floor and basement area is being used as a warehouse/office space without a certificate of use. This is a permitted use in the PLI zone. However, to date, no application has been submitted to obtain the required certificate of use. Number three, the basement office area for which a permit was issued, number 19-42, issued March 7, 2019, has not been issued a certificate of use, waiting for a third-party final electrical inspection, and appears to being used in connection with the Kalel use. I'm also going to read, so that was from Steve Conley. That was dated yesterday, and we'll address each thing. I'm also going to read, back in October of last year, Steve addressed some of the issues. This has kind of been on hold for a while. In a letter dated October 30, 2019, he denied an application for a building permit, and he stated as follows: the narrative on the building permit application submitted by 46 Washington Property LLC is incorrect. The above noted property is located in a PLI zone, not a PO 15. And I'll just say, I believe that may have been corrected, but we'll address that. Section 266.22 of the Village Code, a place of worship, the Kalel, is not a permitted use in a PLI zone. And the last item, he says, since this is a numerical change of use, this application will also require planning board approval for the warehouse/storage. And for the board's benefit and Mr. Churgan, I'm just going to direct you to Village. This is myself, by the way. That was the end of Mr. Conley's letter. What he's referring to, Mr. Conley, is section 266-60A1 of the Village Code, as well as 266-48D1, which in essence indicates that when you have a change of use, which you're applying for here, you would need to basically do some type of plan. And this particular property, given everything that Mr. Conley has said so far that I've read, I think it would make sense if it were to go forward to do that, to do some type of floor plan so that this board and the planning board have something before it and the public, frankly, to see what the intended use is for each part of the building as Mr. Churgan described. And again, that would be pursuant to 260, the two sections that I quoted, 266, 60A1 and 48D1. And again, I'll obviously there's going to be a lot of questions on this, and I'll clarify that as we proceed, but I just wanted to get these things in the record. The last thing I'll put in the record, and this is all part of the file for this matter, is a referral report from the Rockland County Department of Planning dated April 16th of 2020 for general municipal law review pursuant to section 239 L and M of the general municipal law. The reason for the referral is that the property is located on New York State Route 59. The Commissioner of Planning hereby disapproves the granting of the variance. They go through, I won't read everything in detail, but he indicates the department is generally not in favor of granting use variances because of land use precedent that can be set. It then goes through the criteria for a use variance, what the board would have to find in order to grant a use variance, and that would be that the applicant cannot realize a reasonable return on the property. The alleged hardship is unique and does not apply to a substantial portion of the district or neighborhood. The requested variance will not alter the essential character of the neighborhood, but the alleged hardship is not self-created. Now, they go on to say the applicant has not demonstrated any of these issues and a use variance should not be granted. I will note that at the end of their recommended disapproval, they do indicate that they don't really get into any RLUPA or Religious Land Use Institutional Persons Act review. So they do say in this respect, the municipalities are advised that under RLUPA, the preemptive force of any provision of the act may be avoided by changing a policy or practice may result in a substantial burden on religious exercise, by retaining a policy of practice and exempting the substantially burdened religious exercise, by providing exemptions from a policy or practice for applications that substantially burden religious exercise, or by any other means that eliminate the substantial burden. It says proposals of projects are advised to apply for variances, special permits and exceptions, hardship approval, or other relief. So, while their GML review does recommend disapproval on a use variance standard, it does reference our LUPA. So I just wanted to read that into the record. And I guess, Barry, maybe if the board had any questions first and then open it up to the public, for public comment.
Any of the board have anything to say?
I'm curious about what the building inspector found the other day. Is the property currently in use
Yes,
without the proper certificates?
it's being used.
What are the steps? What steps are there planned to remedy that?
Well, this is the first step, and honestly, this I know we're here now in we're here in November. Our application was submitted in March, and unfortunately, because of COVID-19, the whole world stopped. This was one of the steps that we have to get the approval for. We certainly understand that the certificates of use have to be, we would have to obtain them for sure before we use them. I understand from what Mr. Magrino is saying, and I didn't know it before today, that we need planning board approval. So we would be seeking that as well. Every approval that we need, we would have. When I first learned of this, I had spoken to Mr. Connolly about, were there health, safety, welfare concerns, because you don't want to have a any property being utilized if it's unsafe for anybody. And we don't, I don't see any health, safety, welfare concerns, and I don't think he was concerned to the point where we would, have to vacate the building until we get approval. But we will apply for and obtain every single necessary permit before, we'll do that. Absolutely.
Bruce and I did a walkthrough today, and it was apparent that the Colel is already in use and in action. Is that correct?
Yeah. They've been there for a very long time.
Okay, can somebody explain, it's Bruce Simon, can somebody explain to me the process by which somebody uses a facility without certificates of use and then applies for the certificates of use? Is that the normal course, or does it usually go that somebody gets the certificate and then is able to use the property for the approved usage?
It's the latter. Normally.
Right, and just so you know, Bruce, procedurally, to answer your question, they did receive a notice last year, and in response to the notice, they have, come forward. They submitted an application. I'm not sure exactly when it was submitted, but when it was discovered, if you will, they did what you're supposed to do when that happens, and that's apply for the appropriate approvals.
Thank you.
Yeah, just to clarify, the application for this, it was signed by my client on March 5th, 2020. I mean, I know it's a long time since then. I appreciate that, but I think it's not as if they didn't submit it a long time ago. They did, and I'm not blaming anybody. I understand what's going on in the world, but that's why we're here in November as opposed to April.
I'm actually curious. I've seen Mr. Stark here. I realize he was at the walkthrough yesterday as the fire inspector and also as a man with code experience, what he would have to say about this.
Well, when we open the public portion, we could ask him to chime in.
Sorry.
No, that's okay. That's all right.
Anybody else want to speak?
All right. So before we open it up to the public, I'm going to try to do my best, Michael Janito here. And I'm going to mute all. What I'm going to ask, if anybody wishes to speak, is to raise your hand. And you can do that through the phone or on here. I'll unmute I'm sorry, now I'm losing power here. I'll unmute the board members, but hold on a second. Sorry. One second, sorry. What you call technical difficulties. One moment. Okay, so I'm just gonna the board members can unmute. And I guess Barry had sent it to you, but I guess Barry, you have to unmute. You have to hit unmute. But Barry, if somebody wants to make a motion to open the public portion,
I'll make the motion.
Second,
Second. That's Sue. Cary?
yes.
Okay, and all in favor?
Aye.
Okay, and before we do that, Barry, I sent you an ask to unmute. You just have to unmute yourself. Now Bruce is muted. But while we're
Sorry,
going through that,
your question.
if anybody from the public wishes to speak, if you could raise your hand on here and,
All right, I'm unmuted now.
oh, you're great. Okay, you're here. You can run the show.
All right, anybody want to speak from the public? Is there anybody here, there?
Mr. Whalen
Yep.
would like to speak.
Okay,
Hold on, sir, you're still muted.
I'll unmute you. 1 second. Okay, you should be able to unmute yourself, Mr. Whalen.
Thank you. Can you hear me now?
Yes,
Yes.
Thank you. I noticed I live quite near the building. I walk by it quite often. There's no name on the building, so it looks like this is now going to be a synagogue if this motion is approved or application is approved. Another thing is, I live in a building here on Cross Street. It's got 56 owners. Very few of us got this letter. A neighbor got it and alerted me. So isn't everybody in the immediate vicinity supposed to get a notice of this hearing?
well, we can address that at the end, but we'll ask Ms. Bryant, but we'll address that.
Okay. And also, I'd just like to mention that when this group announced their arrival in Suffern, they had cars towed from their parking lot on a Sunday morning for people attending Sunday services at a church across the street. So no notice. I mean, I realize there's no parking sign there, but people have traditionally parked there for years. And then all of a sudden they come out of church and their cars are gone. And then they've got to go to Monzi to reclaim their cars. I thought that was a very poor way to say hello to their neighbors. And then they refused to meet with the church pastor to try and come to a resolution. So that's just my take. Thank you.
Thank you.
Sure.
Anybody else like to speak? Mr. Stark, did you want to comment? Mr. Simon asked.
I can say a few things, Rob.
Okay, go right ahead.
Okay, I did accompany Mr. Connolly with the interior inspection yesterday. I've had some concerns with that building going back almost a year now, when I observed racks and racks of coats and wrappers on rollers being moved in and out of the building. Myself and Officer Ortiz tried to gain entry to the building on probably three different occasions, and we were denied access. But what I found interesting during the inspection, which the Kalal room is, if my memory serves me correct, is about 660 square feet. I think Mr. Churgan alluded to the fact it was 400 and something square feet, so I'm not sure what that discrepancy is there. But in any event, one of the owners of the building was there when Mr. Connolly and I were doing the inspection, and we were asking him a bunch of questions about what's going on in the building, and I found it odd that he couldn't answer any of the questions, and he's one of the owners. Not only are they occupying the east space illegally at this point, but they're also not wearing masks and distancing themselves with the workers that were in there, which was concerning, from a health perspective. I don't know if anybody noted that, Rob, you may have said that there was a small portion of the downstairs that was also being used for the Kalal. I believe that
was in Steve's
comments.
comments from today.
Right, so not only they're using one space, but they're using the space in the basement as well.
Okay.
That's
Okay.
all
Is there anything else?
That's all I have, Rob. Thank you.
Thank you. Is
Thank
there anyone else who wishes to speak from the public? Just give me a second, make sure I'm not missing anything. I don't see anybody with a raised hand. And either through the Zoom or through the or on the camera. So I guess you want to take a motion to close the public participation at this point?
Rob, can I just comment on
Yeah.
what was said?
We'll get to you after that. We do this motion, Joe. You can respond.
Make a
Thank you.
motion to close the public hearing.
Make a motion to close the public hearing.
The public portion, right? Mhm.
Public
portion.
portion of the hearing, yeah.
That's Mr. Hamilton made the motion. Who's the second?
Barry, second.
Barry seconds. All in favor?
Aye.
Okay, Joe, did you want to say something?
Yeah, just briefly, I'm not going to take up too much of your time, but whether it's 400 feet or 600 feet, we asked for, the application is for 400 square feet. So that's all that they could utilize for the COLL, and that should be enumerated appropriately. And if a drawing will do that, for sure, the drawing, a drawing will be submitted. The fact that people weren't wearing masks, it's a troubling thing. I understand that, but I think we have to stay focused on the reason that we're here, and that's a use variance application with respect to a very small portion of this property. The other activities that were described they're permitted activities. They're allowed to use the property for storing coats. Now, I understand they need to have a use permit. I agree with that 100%, but that's not germane to the present application. The present application is a use variance application with respect to 400 out of like 10%, 10% of the property, roughly, if you think about it. It's 4,600 compared to 400 square feet. And again, it's a religious use that we're asking for a use variance where right across the street, it's permitted. If this building were across the street, we wouldn't be here for this because they'd be allowed to use it. And as I said before, the religious uses are provided with, a special, they're given a special position by the New York State courts and by the federal courts. And I agree 100% with what I've heard today, that the use has to be cleaned up, the permitting has to be cleaned up. 100% that has to happen, but that's really not relevant to whether or not they should be able to use 400 square feet for a religious use. Thank you.
Okay, I know I did speak to a few board members and again, without revealing certainly confidence, is that Mr. Churgan alluded to a few issues and I think I addressed them. But there are some legal issues here that he's raised, and I'm just going to quote from a memo that I have, and again, without revealing confidences, and maintaining the confidences, I'm just going to say, in a situation like this where you have a use variance for religious use, the ZBA must weigh the proposed religious and/or educational use in relation to neighboring land uses and cushion any adverse effects on the neighborhood by the imposition of conditions designed to mitigate them, which conditions must be reasonably designed to counteract the deleterious effect of the proposed religious and/or educational use on the public's health, safety, and welfare, for example, traffic, but must not, by their cost, magnitude, or volume, operate indirectly to exclude such religious and/or educational use altogether. So in other words, when balancing this, you obviously have to take into account that it's religious use. And you can impose certain conditions if you so wish, if you go forward. But, you know, in essence, and I frankly, I think Mr. Churgan would agree, if you went through the standard use variance criteria in the state law and then village code, this would not qualify. It's only by the fact that it's a religious use that it does enjoy, if you will, that the ability to, or the presumption, you know, that you have to go through the balancing. And without going further, I'm going to note, I do see somebody has their hand raised, and although we might not ordinarily do it, I think under the circumstances, if the board is okay, I'd like to allow that person permission to speak.
Yeah,
I'd like to
okay.
make a motion to allow it.
Okay.
Second.
Thank you.
Okay.
Thank you.
Yeah. Okay,
Can
Ms.
you
Davies,
hear me?
go ahead. Yes,
Can you hear me?
yes.
I live in the same building as Mr. Whalen, and my concern is what the impact is on the town. I know this will become a tax exempt property. And I know from living in other parts of Rockland County before I moved here, that this can definitely impact upon the economy of the local village. It concerns me, the tax exempt status that they will have, and the, you know, what it will impact upon the village economy and safety and all that. Can someone please address that?
Thank you. Is that the end of your comments?
Yes, yes, it is.
Okay, thank you. And
Rob,
also, well, before we address those, we can take, I see Michael's iPad has his hand raised, so Michael?
He's muted, Rob.
Whoop, hold on a second, Michael. I asked to unmute Michael, so can you unmute? Whoop. One more time. Go ahead. Try it one more time.
Got it?
Got it.
Well, my name is Michael Curley, and as I listen to this hearing, it seems that there are facts that are missing. And I think it's only fair to the public and the board that we have all the facts. The square footage is a question, and whether it is 4, whether it's 6, whether it's, I think we need to look into that. I think we have the issues with the county coming back. I think the MGL letter, the Rockland County letter, dated April 16th, 2020. I recognize this application, as Mr. Churgan said, was in on March 7th of 2019. But the reality is that it may have been that might not be the issue at hand, operating incorrectly before then. But my concern is the actual application now doesn't seem correct. So for me, as a citizen of the community, to be able to give my opinion properly at this point, I think I'd have to have all the facts in front of me, all the proper facts. So I think if you do decide to make any votes tonight, you should consider not making a vote, for the reason that the public portion, the public participation should still remain open after tonight. If you're still going to be looking into it, I just don't want that closed, because I don't think I have all the facts in front of me to make an educated decision. I've talked at other ZBA meetings as far as zoning goes, with apartments above buildings and things of that nature. But Mr. Churgan points out a great fact. He said, right across the street, you can do this. So there's other parts in the village you can do this. So why doesn't he do it where you're allowed to do it? That was the reason why we did our comprehensive plan way back when, to control zoning and to keep things in perspective. So it's not the fact of whether you would, of course, you'd like different religious things in a village. Diversity is fantastic. It has to mean, do you push it in areas that we never meant to put it. And if we're going to do that, I think we need a comprehensive plan and comprehensive study before we jump those guns. I recognize that religion does have certain rights and certain factors, okay? And I recognize this case would, if depending on which way it goes, will go to an Article 78. It won't just die here. It will go to the next step. So the things that I don't want to, I just think we're not educated enough here. I'm not sure and I'm not disrespecting the board. I'm not sure they're educated enough here. But it seems to me, listen, you don't have all the facts. Thank you for your time. Have a nice day.
They've been
Okay,
using
thank
it
you. Does anybody else have any questions?
legally without permits.
Oh, really?
Does anybody else have any questions? Okay, I don't see any. I don't know if Barry, it's okay with you, I'll address the two issues that were brought up. Ms. Davies brought up issues related to
Okay,
losing the tax, if there's a tax exemption. I'm
Okay.
not sure if only part of this is, granted this use, this permission, what the status on the entire building is. But, that's something that certainly can be looked into. But, frankly, that's, more of a planning issue as opposed to, the variance. This board is here for relief from the code, not so much the issue that was raised, but I understand it. In terms of what Mr. Curley raised, I was going to suggest that, some of these issues did come up because that note from Mr. Conley was from back in October of last year. So in reviewing tonight, I noticed those issues that he raised. And to me, I think in order to give it a clearer picture, and I defer to the board on this, it would make sense, and I think Mr. Churgan alluded to it, is to come in with a floor plan. And frankly, you're required to, at least for this use, but since we're doing it and the other areas are still, we're not sure what exactly is happening. There may be permitted uses and some certificates of use, I guess, on the verge of being issued. Show each one, identify it, so that the board can see, those uses in comparison to what the proposed use here is, whether it's an architect plan or a floor plan of some sort, similar to what we did on a much larger scale with the old Novartis property, but certainly not the same scale. But to give it so that the building department and the village can be aware of what the uses are, because again, there was some confusion as to what was going on exactly and et cetera. So I think that would be helpful. And part of that would be, going to the planning board as well. So my suggestion, and Mr. Churgan, I leave to you, you're the applicant in terms of requesting adjournment, would be maybe to put this over until the January meeting, not December, because I don't know that we can get what we need by then. But if we put it to January, and then you can get plans in with the building department, if you can get them in time to get to a planning board in December, that's fine. If not, you can do, one after the other in January, secret and everything else. But I do think for everybody's sake, and again, I defer to the board on this, having that floor plan, would kind of be good for everybody, just so we know what's going on.
I agree with you, Bob. And I think that I'd also like to see some movement on some of the issues surrounding some of the issues we're out of compliance on. I'd like to see some collaboration between the building department and the owners to make sure that we're moving toward a happy agreement between one another.
I agree.
If you're asking me to, if I agree, I hear loud and clear that there's more information that needs to be, the board needs more information. I do agree that a drawing would be appropriate. I also agree that we should collaborate to remove these other concerns that are really extraneous to the use variance application, but definitely relate to the use of the property, obviously. I just want to point out just two small things, and yeah, I agree we should adjourn, but two small things that were said. With respect to the exemption, I do exemptions. That's part of what my practice is. And if you have 1/10 of the property that's a religious use, 90% of the property is not a religious use, not an exempt use. You're not going to get an exemption for, I don't even know that you would get for 10%. I've never seen it. I have seen instances where the property is 50% and 50%, and you get a 50% exemption. But the max anybody would get here in terms of an exemption would be 10%. The rest of the property would be, under any circumstances, would remain, on the tax rolls. And the last gentleman, and I'm sorry I didn't get his name, I think it was Mr. Curley, I could be wrong, who spoke. People were mentioning, that there are health, safety, and welfare concerns, and I don't know that there really are health, safety, and welfare concerns. I don't want there to be health, safety, and welfare concerns. Any application I do, we remove those, and we asked for 20 people in the application. That's what we said it was going to be. We didn't say, we can have an undetermined number of people in that room. We're not trying to turn this building into a shul. I don't want people to have the fears that I'm hearing expressed tonight. We're only seeking to use a very small room in this building for this purpose. But with that, I agree that let's put this over, if the board is willing, put it over to January. I will get the, Rachel will prepare the drawing. We will get it to you in advance of the January meeting. We will endeavor to go to the planning board in December.
Right. My suggestion is and I guess if Rachel's the one doing the plans, is to reach out to Mr. Conley at the building department to coordinate, exactly what he's looking for and go from there.
We will do that.
All right.
Thank you.
So what are we gonna have a vote on whether to postpone it till January?
Yeah, he's continuing. He's requesting a continuance to January. So when is the meeting in January, Lynn?
I do not have a calendar
Would it
in
be
front of me.
21st?
It would be the third Thursday usually.
Yes, that's the 21st.
Okay.
All right. So you want to entertain a motion on that?
I'll make a motion that we continuation to January 21st.
Second.
Okay.
All in favor?
Aye.
And just so there's no misunderstanding, the public participation, that always is permitted. That will be permitted at that time too.
Okay.
Rob, can I say one more thing?
Sure.
As Mr. Whalen brought up the fact that he doesn't believe that, as far as public participation, that everyone in the area was not notified. So I just wanted to bring that
Right.
up.
Well, again, Lynn, I don't know if you have the affidavit is in there as to who was notified. And
Well, we don't do an affidavit. The applicant supplies the names and addresses and the envelopes, address stamped envelopes for everyone. In everyone's application are the names of all the people that were notified. They received a listing from the town of Ramapo
as to the people who
for
were supposed
the
to be notified.
500 feet for
Right.
500 feet. Maybe, I don't know how some would have gotten and not gotten unless it was under a different owner's name in a situation like that. We do get some back. I didn't really receive, I might have received a couple back that were non-deliverable, but that's how the zoning board does the notices.
Okay, so it just asks that it's continued, so the notices will not go out again. But maybe we would ask Mr. Churgan to send a letter anyway to the residents of the nearby apartment buildings, just, if some got it and some didn't, that might be helpful, but it is continued, going to be
I don't
posted.
know. I just want to be clear. I don't have I'm looking in my file. I don't have the names and addresses of them. That's something that's provided by Ramapo, and it's gone.
Not provided by the applicant, usually goes to the town of Ramapo to get the listing because they do it. It's a lot easier than someone coming into our office. Unfortunately, they would have to do it manually. So whoever, I don't know who did it on behalf of the applicant here, but there is a listing of all the names and addresses of everybody that are supposed to be within the 500-foot radius.
Right, and I do have it
You
in
have
the,
that, if you have that now?
Yes.
So then, okay, if we can make arrangements for me to get that list, I will send a letter to every one of them, telling them about 121.
right, and,
So I'll make arrangements for somebody from my office, if not me, to go to the village and copy the list.
right, and you'd probably have to, well, they can email it to you, and you'd probably have to do it for a planning board meeting in any event.
Yeah,
so.
of course, obviously, it's a meeting, yes.
Okay, so we're good. Did we have a motion on that, adjourn to the 21st?
Yeah, we had a motion.
Okay. Okay,
right,
so that's adjourned to the 21st. Thank you, Joe.
All right, thank you very much, everybody. I appreciate you sitting there and listening to us. Thank you.
Thanksgiving.
You too, be safe, everybody.
Thanksgiving.
You too.
Lynn, was there anything else?
No.
Okay.
Okay, so the December meeting,
There currently nothing yet, but if it's an easy, depending upon what they're applying for, depending upon when it comes in, I guess there could be a chance, but nothing right now.
and I guess we would make that the 17th, since the 24th is a holiday there.
17th is the third Thursday, so that.
And with being said, we probably, being that this is the 19th of November, we probably would not have enough time to get someone in with the proper time frame.
Okay, so do you want to just adjourn to the 21st of January then?
Yeah, that's good.
Okay,
Everybody have a nice Christmas.
Everybody have a happy Thanksgiving, Merry Christmas, Happy Hanukkah, Happy New Year, and stay safe.
Whatever. All right. Bye, everybody.
Everybody, bye.
Take care.
Bye.
Bye.